Good morning. Thank you for attending this webinar on the ins and outs of extraterritoriality in bankruptcy cases. My name is Dave Richardson. If you were looking at the first slides, please ignore the email at the bottom. I'm sure Alan Tippy wouldn't mind getting your emails about this, but my own contact information will be at the end of the presentation. I apologize for the 2-week delay in presenting this. 2 weeks ago, I couldn't have gotten through a sentence without coughing. Hopefully, I'll get through the presentation without much coughing today. And the winner of today's webinar will be whoever keeps track accurately of the number of times I accidentally say extraterrestrial. Hopefully I'll keep it down to 0. So the topic today is extraterritoriality with a focus on the avoidance statutes of the Bankruptcy Code. It's an area of law that is extremely unsettled, and I'm going to try to cover where we are today to the extent there is any agreement among the circuits, and with a particular emphasis on where the Ninth Circuit is right now. Between 2010 and 2016, the U.S. Supreme Court handed down 3 opinions that purportedly establish a two-step test for determining whether a particular U.S. law applies extraterritorially. It started with Morrison v. National Australia Bank, followed by Kybell v. Royal Dutch Petroleum, and most recently R.J. Arnabisco v. the European Community. None of these opinions concern the Bankruptcy Code, but the test that they've established is intended to be the test for all federal statutes. This morning I'd like to explore how that test has affected extraterritorial application of the Bankruptcy Code, if at all, with a particular focus on the avoidance provisions. I'm going to start with a brief overview of the landscape prior to 2010, some of which survives today, with a focus on the Ninth Circuit. We'll then look at this trio of Supreme Court cases, then look at how these cases have been applied in the Ninth and Second Circuits, and we'll finish with a brief discussion on the issues of comity and enforcement. In any avoidance action that has an international component, it's likely that the defendant will challenge the court's jurisdiction to apply the Bankruptcy Code extraterritorially. In some cases, the case might actually involve extraterritorial application of the code and might require an inquiry into whether or not extraterritorial application was intended for such a transfer. But in many cases, despite the presence of a foreign defendant or even the foreign location of the asset, the avoidance action might only involve ordinary domestic application of the code, and the real issue for the court might instead be whether it has personal jurisdiction over the foreign defendant. Knowing which scenario you have can hinge on understanding the current landscape of extraterritorial application of the code. Unfortunately, that means wrapping your head around a variety of disagreements between and even within the circuits, including one issue of law that divides the circuits and determines more than any other whether the avoidance provisions of the code may be applied extraterritorially. First, what is extraterritorial application of the Bankruptcy Code? Some of the cases in which the issue arises can involve, for example, sanctioning a foreign defendant for foreign acts over whom the court has personal jurisdiction, the avoidance of transfer of funds in a foreign account to a foreign transferee, or the avoidance of a transfer of domestic real property to a foreign transferee, or entering judgment against that foreign transferee to recover the avoided transfers. These are some of the scenarios that have led to published opinions we'll be discussing today. In some cases, the court found that these were fact scenarios that required extraterritorial application of the code, which may or may not have been allowed. And in others on this list, the court found that the case only raised ordinary domestic application of the code. There's also cases where it isn't entirely clear which decision the court was making. In some cases, suggesting that it was not improper extraterritorial application of the code, but not being clear on whether it meant that therefore it was only domestic application of the code. The first question is, how do you determine if what you're looking at is extraterritorial application or domestic application? Traditionally, courts would apply what's called the center of gravity test, or a similar test, similar nexus test, in Fourth Circuit called the components test. It would look to the circumstances of the transfer to determine whether or not there was a sufficient connection to the U.S. that it was really a domestic transaction that was being challenged. Despite the Supreme Court cases we'll be discussing, which may or may not have erased the scope of the center of gravity test, Many courts still apply it today to figure out whether or not what they're looking at is a domestic or extraterritorial application of the code. If it's a domestic application, then there's no concern about whether extraterritorial application of the code needs to be allowed. There may be related issues of personal jurisdiction in the case of a foreign defendant. There may be issues of comity, despite the domestic application of the code. But not every case that involves a foreign transferee or foreign asset will require an analysis of extraterritorial application of the code. Ideally, the court will carry out this analysis at the outset, so that there's no need to get into a debate over extraterritoriality if the specific transfer at issue involves only domestic application of the code. Although, as we'll see, the Supreme Court thinks it should be done the other way around, and an extensive analysis of extraterritorial application of the code should come first, and only then should you bother to determine if it's even relevant to your case. But, as we'll also see, most bankruptcy courts insist on doing it the other way around and first determining whether or not the transfer is domestic. When it comes to extraterritorial application of the code's avoidance provision, there's one underlying issue that generally determines whether a court will find that the pre-petition avoidance sections, 544, 547, and 548, can be applied extraterritorially, and that is whether property of the debtor that was transferred pre-petition, or at least whatever interest the debtor retains in that transferred property, is property of the estate as of the petition date, or only becomes property of the estate after there is either a judgment avoiding the transfer or the property has been recovered under Section 550. As we'll see in more detail, the reason that this issue is key is that the circuits are in agreement that the Bankruptcy Code applies extraterritorially to the extent that it reaches property of the estate wherever located. And in cases applying or refusing to apply the avoidance provisions extraterritorially, they generally fall on either one side of this issue or the other. I've highlighted these sections of Section 541 that this issue generally revolves around. The definition of property of the estate in Section A1 includes all legal or equitable interests of the debtor in property as of the commencement of the case, which has led some courts to believe that the debtor holds an equitable interest in property that it will seek to recover that falls under Section A1. Other courts, however, look to Section A3, providing that property of the estate will include any property that the trustee recovers under Section 550, among other sections. And they hold that that section has no meaning unless any interest the debtor would have at the commencement of the case, any equitable interest, is not considered property of the estate. And transferred property only becomes property of the estate when it's recovered. A third position that we'll see is that some courts look to Section 548 and the reference to an interest of the debtor in property and hold that the definition of property of the estate is entirely irrelevant to whether or not Section 548 can be applied extraterritorially. There are basically three positions among the circuits. The first is taken by the Fifth Circuit, which is held in a couple of cases that when a debtor is forced into bankruptcy, it makes the most sense to consider the debtor as continuing to have a legal or equitable interest in the property fraudulently transferred within the meaning of Section 541. The Second Circuit initially followed that position, but decided in 1992 in In Re Colonial Realty that it had been led astray, and that the reference in Section 541A3 to property recovered by the trustee indicates that Congress did not intend the property not yet recovered would be property of the estate. The Fourth Circuit has come down somewhere in the middle, although it agrees with the Fifth Circuit view that a debtor's interest in property is not property of the estate. It went on to explain in the heavily cited case French v. Lieberman that it doesn't really matter whether or not the Fifth Circuit or the Second Circuit is correct, because Section 548 itself provides that it applies to interests of the debtor rather than property of the estate. Where the Ninth Circuit comes down on this issue is something we'll get to when we look at the post-Supreme Court cases later in the presentation. Given this disagreement between the circuits, perhaps one day we'll get a definitive decision from the Supreme Court. But in the meantime, whether the avoidance provisions of the Code apply extraterritorially largely comes down to whether or not you're in a circuit that holds that transferred property is not property of the estate until recovered because of the reference in 541A3, or holds that a debtor's equitable interest in property includes the debtor's interest in property that was fraudulently transferred pre-petition. So the purpose of this presentation is to explore whether or not the Supreme Court test has brought uniformity to the issue of extraterritorial application. This one outstanding disagreement over the definition of property of the estate among the circuits is the primary reason that there's still a lack of uniformity on case law on this issue. I want to start by discussing the landscape of the extraterritorial issue prior to 2010, and then move on to the three Supreme Court decisions that may have changed the test that applies. Prior to 2010, many cases discussing extraterritorial application of the Bankruptcy Code started with the nexus or center of gravity test that I mentioned earlier, looking at as a first step to whether or not the challenged transaction is a domestic or foreign transaction. For example, if a parcel of real property located in California was transferred by its California owner to a foreign transferee and the deed was recorded in Los Angeles County, the court would likely conclude that this was a domestic transaction with a center of gravity here in California, and therefore conclude that an avoidance statute or other Bankruptcy Code section could be applied to the transaction without raising extraterritorial concerns. Instead, the issue that might need to be addressed would be whether or not the court has jurisdiction over the foreign transferee. On the other hand, if the court was looking at a transfer of funds between two Swiss bank accounts held by citizens of other countries, it would likely conclude the transaction had a foreign center of gravity and would then turn to whether or not the applicable section of the Bankruptcy Code was meant to apply extraterritorially to regulate such contract. In cases that involved a foreign transaction, the court would typically then engage in a two-step analysis. The Ninth Circuit and Second Circuit had similar sounding tests in place before 2010, which asked first if the language of the statute overcame a presumption against extraterritorial application, and if the statute provided specifically that it was to be applied worldwide, then the court could proceed to do so. But if the statute didn't contain such language, then the court would conduct a form of an effects test to decide whether the court could decide that Congress had really intended that it be applied extraterritorially, even though the statute does not specifically say so. The Ninth Circuit's version of this test is discussed in a frequently cited case, Hong Kong and Shanghai Banking Corp. v. Simon, in re. Simon, 153 F. 3rd 991. And there the court started with the presumption against extraterritorial application of the code, and then looked to whether or not the regulated conduct was intended to and results in substantial effects within the United States. The Second Circuit had what was referred to as a conduct and effects test, described in SEC v. Berger, which looked first to whether the wrongful conduct occurred in the United States, and then whether the wrongful conduct had a substantial effect on the United States or upon U.S. citizens. One key difference between these two tests, despite the similar analysis of conduct and effects, is that whereas the Second Circuit's test focused on the conduct of the party and the effects of the challenged transaction, the Ninth Circuit test also focused on the effect of not applying the avoidance statute extraterritorially. So while one looked primarily at the conduct and effects of the transaction itself, the Ninth Circuit also looked at what effects would occur if the court did not apply the statute. Rather than try to discuss every case published within the Ninth Circuit prior to 2010, I want to focus on two that have been most widely cited and to some extent still apply to the debate today. The first is the case I cited just a moment ago, Hong Kong and Shanghai Banking Corp. in re. Simon. In Simon, a bank sought declaratory relief to confirm that it could attempt to collect on the debtor's guarantee from assets in Hong Kong, and that this wouldn't violate the debtor's bankruptcy discharge on the grounds that a discharge couldn't apply extraterritorially in Hong Kong against a Hong Kong bank collecting Hong Kong assets. The bankruptcy court, affirmed by the district court, held that the discharge couldn't be enforced in Hong Kong, but could be enforced against the bank and its assets in the United States if the bank were to take any action against the debtor's assets in Hong Kong. The bankruptcy and district court's reasoning was that because a bankruptcy court's in rem jurisdiction reaches property of the estate wherever it's located, the discharge injunction properly enjoins actions against property of the estate wherever the action might be filed. And sanctioning a creditor who can be reached in the U.S. for taking such action in a foreign country is therefore a domestic application of the Bankruptcy Code and doesn't involve issues of extraterritoriality. In effect, if the court can assert personal jurisdiction over the creditor acting abroad, then the court is applying sanctions in a domestic manner. The Ninth Circuit affirmed, but possibly on different grounds. The Ninth Circuit began with a lengthy analysis of whether the Bankruptcy Code applies extraterritorially, and begins with a sentence that I think deserves a moment of consideration, saying, Congress has the unquestioned authority to enforce its laws beyond the territorial boundaries of the United States. By contrast, a few years later, the Supreme Court started its Nabisco opinion with the statement, it's a basic premise of our legal system that, in general, United States law governs domestically but does not rule the world. Two very distinct ways of saying essentially the same concept. And I tend to find that you can get a sense of where a court is headed in an opinion by whether it starts with a general statement about the ability of the U.S. to assert its laws internationally or the limits on the ability of the U.S. to assert its laws internationally. Now, despite the different perspective, though, both these two opinions and virtually all others start with the premise that there is a presumption against extraterritorial application of a statute unless the language of the statute provides for it. One place where courts differ is what actually constitutes the language of the statute. In Simon, the court noted that the presumption against extraterritoriality can be overcome by sources beyond the plain wording of the statute, including legislative history and even administrative interpretations of the law. After laying out its version of the effects test that we saw earlier, the Ninth Circuit turned to its analysis of the transaction. It started by holding that the district court had correctly held that Congress clearly intended extraterritorial application of the Bankruptcy Code, which is a very broad statement, although explained a little later that its application of the Bankruptcy Code as it applies to property of the estate. The Ninth Circuit explained that this was meant because the definition of property of the estate applies to property wherever located and by whomever held, creating the legal fiction that all of the debtor's property, wherever located, is legally located within the jurisdictional boundaries of the court. This holding is one that you'll find is uniform across the circuits, which is why extraterritorial application of the avoidance statutes usually comes down to whether or not the target of the action is considered property of the estate. The Ninth Circuit then explained that there is no functional difference between the automatic stay that applies at the outset of the case and the discharge that is entered at the end of the case. Both seek to protect property of the estate wherever located, and therefore the debtor's discharge enjoined a Hong Kong bank from proceeding against assets located in Hong Kong. The court then turned to whether sanctioning the creditor was an appropriate remedy, concluded that because the creditor had apparently consented to the bankruptcy court's jurisdiction by its actions in the case, therefore an order sanctioning the creditor for his actions in Hong Kong wasn't a, quote, improper extraterritorial application of the code. Those are interesting words because they could be taken a couple of ways. The district court had held that the sanction order was a domestic application of the code. The Ninth Circuit described the district court's decision in the words that are now on the screen. While the Ninth Circuit affirmed the district court, it did so by holding that the sanction order wasn't an improper extraterritorial application of the code. It didn't say that the bankruptcy court had applied the code domestically and properly, and it leaves open the question of exactly whether the Ninth Circuit meant to say that the code was being applied extraterritorially and properly, or because it was a domestic application, it wasn't therefore a challenged improper extraterritorial application. We can get some guidance from the concurring opinion of Justice Hall, who states, that he concurs in the opinion because, quote, I do not believe that extraterritoriality is implicated in this case. And if you add that to the majority statement that the district court was entirely correct in its analysis, I think you can conclude that the Ninth Circuit meant to say that there wasn't an improper extraterritorial application because it was a proper domestic application. Now, when the Ninth Circuit moved on to questions of personal jurisdiction, and the court found that the Hong Kong bank had taken sufficient actions in the bankruptcy case to have consented to the bankruptcy court's jurisdiction. It also went on to state that it was not deciding whether extraterritorial application of the code could reach a creditor who hadn't participated in the bankruptcy case. The statement suggests that the Ninth Circuit is saying that whether or not the court can assert personal jurisdiction over the creditor or defendant is part of the extraterritorial analysis. And if it is saying that, it's quite alone in mixing the two concepts together. I think the better view is that courts recognize that whether or not the court has personal jurisdiction over the creditor or defendant is an entirely separate legal issue from whether or not the statute was meant to be and can be applied extraterritorially. And personal jurisdiction is a question that typically has to be resolved whether or not the statute is going to be applied extraterritorially or domestically if the transferee is a foreign party. So perhaps all the Ninth Circuit meant is that even after you resolve the policy question of whether the statute is intended for extraterritorial application, a court can't effectively apply it extraterritorially if its jurisdiction can't reach the creditor or defendant. But I don't think the court's language is particularly clear on that issue. The second pre-2010 case that I want to discuss from within the Ninth Circuit is a bankruptcy court case that is often cited because it takes a position on the question of property of the estate. That's Midland Euro Exchange v. Swiss Finance Corp. in re Midland Euro Exchange, 2006 bankruptcy court opinion, which I'm quite familiar with from having filed the involuntary petition in that case, although I wasn't involved in this particular adversary proceeding. And in this opinion, the bankruptcy court sided with the Second Circuit's view that Section 548 cannot be applied extraterritorially because fraudulently transferred property is not property of the estate until the transfer had been avoided. In this case, the trustee sought to recover funds that a foreign affiliate had transferred to a foreign currency trader. The court noted at the outset of its extraterritorial analysis that this issue arose on a motion to dismiss, and so the court had limited facts before it that could allow it to inquire into the regulated conduct of Section 548. So the court inquired into whether the language and intent of Section 548 could overcome the presumption against extraterritorial application, and focused its analysis on whether a debtor's interest in transferred property could qualify as property of the estate and permit the extraterritorial application of the statute. The court sided with the Second Circuit's position and against the Fourth and Fifth Circuits, deciding that a debtor's interest in recovering property that was transferred pre-petition does not make that interest property of the estate. Therefore, the court held that Section 548 could not be applied extraterritorially and dismissed the adversary proceeding. Now, Midland isn't controlling, of course, but unless there's some other authority from a higher court in the Ninth Circuit, it could certainly be persuasive to any other bankruptcy court. But as we'll see a little later, I think there is enough authority from the Ninth Circuit to overcome any persuasive role that the Midland Euro case might take in the analysis. Which brings us finally to the Supreme Court decisions of 2010 to 2016. The first case is Morrison v. National Australia Bank. And it's a case in which the court dismissed the Second Circuit's long-standing application of a nexus test to determine whether Section 10b of the Securities and Exchange Act of 1934 applied extraterritorially. The Supreme Court held that looking to the facts of each particular case to determine if there is a sufficient nexus to the U.S. erases congressional intent and leaves parties unable to discern how the law might be applied in each particular case. The first issue in the case was whether the Second Circuit had applied the proper test to determine whether Section 10b could be applied extraterritorially. And the court criticized the long-standing conduct and effects test because it felt that the case did not properly examine the congressional intent behind the statute. Justice Scalia criticized the test as leading to results that were actually contrary to congressional intent and extremely unpredictable and inconsistent. Instead, Justice Scalia returned to analysis of congressional intent behind the statute and began with, of course, the presumption against extraterritoriality. He explained that the language to overcome this presumption can be found in sources beyond the plain wording of the statute, going farther than the Ninth Circuit had done in re Simon, saying that the presumption can be overcome by indications found in context rather than the explicit wording of the statute. saying that it could be found in whatever sources of statutory meaning one consults to give the most faithful reading of the text. After reviewing legislative history and other sources, the majority opinion concludes that Section 10b wasn't meant to apply extraterritorially. And because the court has struck down the Second Circuit's alternative conduct and effects test, that was the end of the issue. Section 10b does not apply extraterritorially. The appellants argued for a focus test to continue to be applied in order to find that the case was really a domestic transaction that didn't even involve issues of extraterritoriality. And Justice Scalia went through the analysis to confirm that the congressional focus of Section 10b was sales of securities on domestic exchanges. But since the conduct at issue was sales on foreign exchanges, then the presumption against extraterritoriality could not be overcome by an examination of the focus of the statute, and the case before it did not involve domestic application. Finally, the parties argued for a significant and material conduct test, which Justice Scalia dismissed outright. Now, there isn't anywhere in the opinion where Justice Scalia says, here is a new two-part test that we're putting into place. But as we'll see, that's how it's been largely interpreted by subsequent opinions. Even in the concurring opinion filed by Justices Stevens and Ginsburg, they refer to the court's new transactional test as just a single-step analysis. So if you had asked me in 2010 what the Morrison test is for determining extraterritoriality, I would have said that it's a fairly strict constructionist review of statutory language and other sources of interpretation, and that if a statute cannot be applied extraterritorially by its congressional intent, then the only way to get around it is proving that what you're really dealing with is domestic intent, domestic application of the law, purely by dealing with the regulated conduct and where the conduct took place. In 2013, the Supreme Court came down with Kybell v. Royal Dutch Petroleum. And in Kybell, the court looked into whether the Alien Tort Statute applies extraterritorially. Chief Justice Roberts laid out a lengthy analysis of the language and history of the statute that only addressed the Morrison plain reading test. The court examined the history and intent of the statute to conclude that it wasn't intended to reach more than a very limited category of foreign actions, such as piracy. And if that were the end of the opinion, it would suggest to me, as Morrison itself suggests, that the Morrison test is simply a review of the statutory language and history. But the court then added a section that states the following: on these facts, all the relevant conduct took place outside the United States, and even where the claims touch and concern the territory of the United States, they must do so with sufficient force to displace the presumption against extraterritorial application. As I read that paragraph, the court is suggesting, in addition to the analysis of the language intent of the statute, you can also analyze whether significant conduct that touches and concerns the territory of the U.S. does so with sufficient force to displace the presumption against extraterritorial application, meaning allow the court to apply the statute extraterritorially. And if that is the meaning of this paragraph, it's a departure from Morrison, adding a second potential line of inquiry into extraterritorial application. For even if the language and history of the statute does not suggest an intention to apply it extraterritorially, substantial effects in the U.S. caused by the challenged transaction could be enough to displace the presumption. Justice Roberts cites to Morrison for this concept, but every time I read Morrison, this concept only seems to come up when Justice Scalia is criticizing the Second Circuit's test or specifically dismissing the alternative arguments proposed by appellants, which raises the question of whether the Kybell opinion truly alters Morrison, creates a second test to be considered, or simply adds some dicta that miscites what Morrison intended. I'm not sure we get any answers to this in the next opinion that the Supreme Court handed down in 2016, which is RJR Nabisco v. European Community. The case examined the potential extraterritorial application of RICO, and the court described both Morrison and Kybell as establishing a very simple two-step test that is focused solely on the language of the statute and its history, and then, if the presumption is not overcome, whether the case really involves domestic application and doesn't even involve issues of extraterritoriality at all. The Nabisco opinion says nothing about the Kybel conducts and effects language. The court didn't discuss it when discussing Kybel, and instead only references the role that conduct plays when it's determining whether or not the court is really applying a statute domestically rather than extraterritorially. I can find nothing in the Nabisco opinion that directly addresses the conduct language of Kybel, and nothing that suggests that there is a second test. Now, to help show the question that I think is raised by Kybel but not answered in Nabisco, I've redlined the statute, the statement that was in Kybel, and how I think it would need to have been rewritten in order to carry out the holding of Nabisco. We need to replace the reference to displacing the presumption against extraterritorial application and instead refer to application of the statute domestically. So at the end of these three opinions, it's not entirely clear what we have. A one-part test that looks to congressional intent turned into a two-part test by a version of the pre-existing center of gravity examination to determine if you even have extraterritorial or domestic application, or a test that Kybel suggests with parts 1A and part B, and an alternative means to overcome the presumption against extraterritoriality if you can show that the conduct affected the U.S. in a manner that was significant enough to overcome the presumption. As you'll see, this is a question that gets answered differently by different courts and has created a second split among the circuits that could find a future Supreme Court case giving us more guidance on extraterritorial application of statutes. So I want to turn to what the impact of this Morrison test is in bankruptcy cases. And this slide shows the pre-Morrison tests in the Second and Ninth Circuits and what the Morrison test is most frequently cited as being, the two-step test to determine if the statute was intended to apply extraterritorially, and if not, whether the focus of the regulated conduct in the case is really domestic. In looking to how the Ninth Circuit has addressed this test, I want to take the cases a little bit out of order and start with a couple of non-bankruptcy cases because they relate to everything I've just said about the Kybel opinion. The first case is Mujica v. AirScan, 2014 case, in which the Ninth Circuit considered whether the Alien Tort Statute applies extraterritorially. Rather than discuss Morrison in any detail, the Ninth Circuit focused almost entirely on the Kybel case. The court started with the holding in Kybel that nothing in the Alien Tort Statute and its history could overcome the presumption against extraterritoriality, and then turned to the language that I've described as a possible test 1B of the Morrison test, and the court stated, although the court, meaning the Supreme Court in Kybel, did not hold that plaintiffs may never bring ATS claims based on extraterritorial conduct, it made clear that in order to be viable, any such claims must, quote, touch and concern the territory of the United States and must do so with sufficient force to displace the presumption against extraterritorial application. And the Ninth Circuit referred to this a few paragraphs later as Kybel's touch and concern test. And the court ultimately deferred to Columbia's courts on the issue before it. But the Ninth Circuit has repeated its belief that Kybel set up a second test in a case that's led to several published opinions by the Ninth Circuit, John Doe v. Nestle. And in a 2014 published opinion, repeated that Kybel articulates a new touch and concern test for determining when it is possible for an ATS claim to seek the extraterritorial application of federal law. And a year later, in an en banc dissent to an en banc opinion, one justice wrote, "The majority creates a second circuit split by misinterpreting the Supreme Court's decision in Kybel." So which is it? Did Kybel establish a new test for applying a statute extraterritorially when its language and history says otherwise? And if so, does it only apply to ATS claims? Or did Kybel just add some language addressing how you determine if the requested application of the statute is really domestic application that's been misinterpreted by courts since? A recent opinion from the Fifth Circuit, Adhikari v. Kellogg, Brown, and Root, includes detailed discussion from the majority and minority opinions as to whether the Kye Bill touch and concern language is a separate test or meaningless dicta that should be ignored in favor of the simplified description in Nabisco. So even though this dispute has arisen in the context of the Alien Tort Statute, it has been applied in cases pertaining to other statutes and has been interpreted as widely as the descriptions I've given you so far, as anything from another test to overcome the presumption against extraterritorial application of a statute, or just the means of determining if the application is actually domestic. And although the vast majority of cases that discuss Kye Bill do concern the Alien Tort Statute, there are a couple of cases I put up here that address other statutes. Mesho v. Higginbotham, the D.C. Circuit, dealt with a Bivens action for Fourth Amendment violations and applied the Kye Bill touch and concern test. A bankruptcy case in the Southern District of New York that just came down a couple weeks ago cites Kye Bill's touch and concern language, but does so more in the way that Nabisco suggested it should apply, to look to whether or not the statute was being applied domestically or foreign, or extraterritorially, and it dealt with 11 U.S.C. 547. So for these reasons, I think it's important to know whether Kye Bill has given us a second test for getting around the presumption against extraterritoriality, or whether it's simply part of the domestic analysis. Because even though the issue hasn't yet arisen in the context of a fraudulent transfer action, a separate touch and concern test would apply regardless of whether or not the circuit you are in believes that the debtor's interest in property to be recovered is property of the estate. For example, even though the Ninth Circuit's position, we'll get to it in a moment, may be potentially unclear, the Ninth Circuit is very clear that there is a separate touch and concern test, and therefore it should be a part of any argument that is made to try to apply Section 548 extraterritorially in the Ninth Circuit. But given the split among the circuits, we'll likely get an answer someday. Just understand that in the meantime, this should be an important part of any argument you make to the court. The case that gives me the opinion that the court may also be leaning towards the Fourth and Fifth Circuit view that transferred property is property of the estate is a case that actually has nothing to do with Morrison. In 2012, the Ninth Circuit published the case Sampson v. Western Capital Partners, in re Blixeth, which the court stated, moreover, property of the estate includes non-debtor interests in property recovered or recoverable through the Bankruptcy Code's transfer and lien avoidance provisions, citing to Owen v. Owen, a 1991 Supreme Court case. Now, the court in Blixeth had been asked to consider the scope of Section 362 relating to pledged personal property, and it reached this holding in connection with that discussion. But the statement wasn't pulled from thin air. As you can see, the court cites to the 1991 Owen opinion, which makes the same statement, but also cites to Section 541A3. The thing to note, however, is that Section 541A3 doesn't use the word recoverable. It only uses the word recovered. So the court appears to be going beyond the specific language of Section 541A3 in using the word recoverable. So it raises the question, is this an indication that the Ninth Circuit is favoring the view of circuits holding that property of the estate includes property that is not yet recovered and is only recoverable? Or does recoverable mean avoided but not yet recovered, suggesting that the Ninth Circuit is more likely to favor a view that transferred property might only become property of the estate once there is a judgment avoiding it? I don't think it's the latter, because its reference was to the avoidance provisions of the Code, not the recovery provisions. But another factor to keep in mind is that though this is a per curiam opinion of the court, it's one in which the court completely adopted the BAP's ruling. And the wording that is on the screen is actually wording written in the BAP's original ruling. So you could argue that perhaps the Ninth Circuit didn't really mean or even understand what was said here in this wording, because it was taking in the overall opinion of the BAP. That's an issue for a lot of debate, and perhaps we'll get a clearer understanding from a future Ninth Circuit decision. Now, a couple of bankruptcy courts have also followed the Supreme Court Owen quote, referred to here in this case, and have dealt with it when addressing pre-petition transfers, and have held that it does carry the meaning that's suggested by the Ninth Circuit in Blixeth. One of those is a bankruptcy court opinion published in New Jersey in 2009, where the court found that property transferred before the petition date was recoverable under 547, and it followed Owen to hold that such a recoverable interest was property of the estate. And Judge Peterson in Montana has published a couple of cases in which he makes the same statement, citing that all three sections of the avoidance provisions to recover pre-petition transfers seek to recover property of the estate under Owen. None of these bankruptcy cases address issues of extraterritoriality, but they do provide more fodder to the debate over whether or not a debtor's equitable interest in transferred property is property of the estate, and whether the Ninth Circuit meant what it appears to have said in Blixeth. The Ninth Circuit had a chance to weigh in further on this issue and other extraterritorial issues in 2014, and unfortunately largely punted. The case is Kismet Acquisition v. Eisenhower, Henry Eisenhower, and it's the first Ninth Circuit case that applied the Morrison test to avoidance claims to recover transferred property. In this case, real property located in Mexico. The facts pertaining to the extraterritoriality question are fairly simple. Mexican law forbids foreign nationals from owning real property near the coast. Two U.S. residents used a trust mechanism to acquire property, whereby title was held by a Mexican bank and they had the right to use the property. Right before filing bankruptcy, they acquired a shell company and transferred the property rights to that company. Then after the petition date, they transferred those rights from the company to transferees who were American residents but Mexican citizens. So there was a pre-petition transfer to the company and a subsequent post-petition transfer of foreign property to American residents from a Mexican company. The bankruptcy court entered an order finding that the debtors and the shell company were alter egos, and therefore the subsequent transfer was an unauthorized transfer of property of the estate, holding that the Mexican real property was property of the estate at the time of the post-petition transfer. Therefore, the bankruptcy court avoided the transfers and ordered the transferees, who were U.S. residents, to execute whatever documents were necessary to undo the transfer, or as an alternative, face a damages judgment against them for the value of the transfer. The Ninth Circuit opinion involves very little analysis of extraterritoriality issues, but does begin with a brief statement outlining the two-part Morrison test, and then finding that the bankruptcy court properly held, following Simon, that Congress intended extraterritorial application of the Bankruptcy Code as it applied to property of the estate. And given the alter ego ruling which the Ninth Circuit upheld, the court agreed that the Mexican real property was property of the estate at the time of the post-petition transfer, and therefore was an unauthorized post-petition transfer that could be recovered under Section 549 and Section 550. But Eisenhower doesn't help us explain why the application of part of the Bankruptcy Code in Simon was a domestic application, while in this case it's proper extraterritorial application. The Eisenhower decision affirms extraterritorial application of Section 549 to reach transferees who were U.S. residents and over whom the court had personal jurisdiction for a transfer that was carried out in a law office in San Diego. If Simon was domestic application of the code, reaching actions that took place in Hong Kong against Hong Kong assets, and Eisenhower is extraterritorial application of the code, reaching a transfer of foreign assets that was transferred in a law office in San Diego by U.S. residents, it begs the question of what is the difference that makes one extraterritorial and one domestic? Simon and Eisenhower both concern property of the estate that's outside of the U.S. Both concern an order of the bankruptcy court issued against a party over whom the court has personal jurisdiction and either sanctions that party for foreign conduct or orders the party to carry out potentially domestic conduct and face sanctions for refusing. So why is Eisenhower extraterritorial application of the code, but Simon is domestic application? I think the only plausible explanation is that the court was influenced by the immovable nature of the real property in Mexico. And I think you could also argue that in both Simon and Eisenhower, holding was more outcome-driven than policy-driven. But given how little is explained by the Ninth Circuit in both cases, I think it's a matter that remains up for debate. At the very least, it's a demonstration of how thin the line can be between a transaction that only implicates domestic application of this code and a transaction that requires extraterritorial application. So where are we now in the Ninth Circuit? Unfortunately, I don't think there's a case that gives us a clear answer. I think you could piece together an argument for extraterritorial application of the avoidance provisions, starting with the first step of the Morrison test. I think you can argue for application of the Fourth and Fifth Circuit's position on property of the estate, given the broad statements in Simon and Eisenhower about application of the code to property of the estate wherever located, and the Blixseth statement that property of the estate includes property that is recoverable from transferees. I think you can make a good argument that the Ninth Circuit is meaning to hold that sections 544, 547, and 548 provide by their terms that they apply extraterritorially to actions to recover a debtor's interest in transferred property. And if the court is unwilling to accept that argument, you can turn to step 1B of the what may be step 1B of the Morrison test under Kybell, accepted by the Ninth Circuit as a legitimate alternative test in Mujica, and argue that the transaction touches and concerns the U.S. to such a degree that it justifies extraterritorial application of the statute. However, as we've seen that concept applied, both in the Supreme Court's Kybell case and the Ninth Circuit's Mujica case, I still don't personally see much of a difference between that test that looks to justify extraterritorial application of the statute because of the degree to which it touches and concerns the U.S., and the older and initial center of gravity test that is used to determine if you even have an extraterritorial issue in the case. And other courts who hold that Kybell is not a separate test, I think would agree, since they hold that the touch and concern language in Kybell is part of the test to determine whether or not you have domestic application in the first place. And I'll give you an example. If a debtor transfers property to a foreign transferee, thereby depleting the estate and harming potential recoveries of U.S. creditors, does application of Section 548 require extraterritorial application that can be justified because this transaction touches and concerns the U.S. to a sufficient degree? Or is it domestic application because the conduct and effects of the transaction show that it was primarily a domestic transaction because of the way in which it touches and concerns the U.S.? I think it's a very fine line. But here in the Ninth Circuit for now, to whatever extent the facts of your transaction might not have enough domestic conduct to be considered domestic application of the avoidance statute, you may still be able to get extraterritorial application if the conduct touches and concerns the U.S. to a sufficient degree. So where do we stand now? Without more clarification, which I expect will happen before too long, I think you still begin with the argument that your case might only involve domestic application of the statute. And someone who wants to avoid domestic application can argue that Morrison only permits analysis of the location of the conduct, while other courts have continued to broadly apply the old center of gravity test that looks to the entire circumstance of the transaction. If the court concludes that the transaction requires extraterritorial application of the statute, then I think you turn to the first prong of the Morrison test and inquire into the language and history of the statute, arguing that the Ninth Circuit appears to be favoring the view that a debtor's interest in transferred property is property of the estate, followed by analysis of the conduct that touches and concerns the U.S. as an alternative means of overcoming the presumption. Now, these issues have had much more development in the Second Circuit since the Morrison cases came down. And as I see I'm starting to run short on time, I don't think I'm going to be able to get through all of those opinions. So I'm going to very briefly run through the slides, which you can look at in more detail after the presentation is over and you receive a copy of the materials. Since 2010, there have been 3 opinions in the Madoff cases, which have come down very different positions as to whether or not property of the estate includes transferred property and whether or not Section 548 can be applied extraterritorially. There are also other bankruptcy court decisions that have come down since 2016 that, again, come down on opposite sides of the question. Lyondell Chemical deciding that transferred property is property of the estate and that therefore Section 550 can be applied extraterritorially. In a more recent case, determining the opposite outcome in connection to Section 547. And I want to rush through those opinions because I'd like to quickly cover the last two issues of comity and enforcement. But essentially, the point I'd wanted to make with all of the Southern District of New York cases is that under the current status of the law, there's support for whichever argument you want to make to the court. If you want to argue that Section 548 can be applied extraterritorially, you can find a couple of opinions from the Southern District of New York that will support that argument, and vice versa. And in almost every case that deals with extraterritorial application of the code, the court will then turn to the issue of comity. International comity is essentially deference to the foreign courts or the foreign country. As the Ninth Circuit briefly explained in Simon, it's the recognition which one nation allows within its territory to the legislative, executive, or judicial acts of another nation, having due regard to both international duty and convenience, and to the rights of its own citizens or of other persons who are under the protection of its laws. Comity is a judicially developed doctrine, and is essentially abstention. A foreign defendant is likely to argue that even if a particular statute should be applied extraterritorially according to congressional intent, deference to the laws of the foreign nation where they're located compels the court to refrain from applying the statute to the challenged transaction. It arises most commonly in cases, at least in bankruptcy situations, when there are other insolvency proceedings underway in foreign countries. It arose in the Madoff case, where the Southern District of New York felt that some of the defendants were dealing with insolvency proceedings of their own in foreign countries, and whether or not their subsequent transfers to further transferees should be clawed back were issues to be addressed in those insolvency proceedings. Second Circuit case in 1996 that's widely cited is In re Maxwell Communications, which a court looked to an insolvency proceeding that was going on in the UK, along with the proceedings before it in the US, and determined basically a center of gravity test by looking to the entirety of the circumstances of the transaction and concluding that based on the, quote, Englishness of the debtor, the court would extend comity to the UK insolvency proceeding. In Simon, the Ninth Circuit looked to the issue and asked whether it was required to vacate the bankruptcy court's injunction by the doctrine of comity. It concluded that it was not. The Ninth Circuit explained that the Bankruptcy Code provides for a flexible approach to international insolvencies, in which there's a general deference to the country where the primary insolvency proceeding is located. And in Simon, unlike Maxwell or the Madoff cases, the sole bankruptcy proceeding was in the United States. Therefore, the court found that there were no grounds to be applying comity and to be refraining from entering judgment. The final issue is enforcement. Arguments over extraterritoriality can be very time-consuming and very expensive. And at the end of the proceedings, you may find that you don't have an enforceable judgment. In each case that involves extraterritorial application, the property or the transferee is usually outside the U.S. If your transferee is foreign and the subject property is located outside the U.S., your ability to recover anything at all may be limited to whether or not that defendant has other property in the U.S. that could be recovered on a judgment for the value of the transferred property. The court in Eisenhower had U.S. residents to reach with its order to reconvey the Mexican property or pay damages judgments. But as other opinions that were published in the Eisenhower bankruptcy case show, those defendants went to extraordinary lengths to refuse to reconvey the property. And those subsequent opinions don't tell us if there were U.S. assets that could have satisfied the judgment. And so it raises the question of how effective an avoidance judgment can be if your only means of obtaining a recovery of the asset is to return to a foreign court. What if the transferees of the real property in Eisenhower hadn't been U.S. residents? Would a Mexican court recognize the bankruptcy court's avoidance judgment and apply it in an action filed in Mexico to reach the real property? Would the transferees have a home court advantage? Is a Mexican court going to be sympathetic to U.S. bankruptcy trustee who wants to claw back a villa on the coast of Mexico to be administered in a U.S. bankruptcy court? I think anyone going into these issues has to ask themselves whether they think there will be enough value in the judgment they hope to obtain to justify the expense of going through all of these issues. So I think we're out of time, but I appreciate you taking the time to listen to these issues this morning. We will be sending out the materials, and if you have any questions, feel free to email them in and I'll get back to you. And if you do brief these issues, please let me know the outcome. I'd like to keep up on where courts in the Ninth Circuit are heading on this issue. Thanks very much and have a good day.